as we've all learned from the state of New York versus Donald Trump, she would have to post bond in an amount equal to the judgment.
Budget Stadium Towing versus Latoya Carroll, number 23C 0224.
Good morning, or good afternoon, Your Honor. David Fanter on behalf of the plaintiff.
Good afternoon. Please state your name, ma'am.
Good afternoon. Name is Latoya Carroll.
Good afternoon, ma'am. All right, we're here on Ms. Carroll's objection to the garnishment in these matters, or in this matter. Ms. Carroll, the law is very specific as to how you can attack a garnishment. I can tell you from rereading your actual objection, your argument here is that the vehicle was signed over and provided to the plaintiff in agreement, is your words, that there wouldn't be any further charges or fees. That is attacking the actual original case and the underlying matter, and you can't do that in an objection to a garnishment. It has to be one of the reasons that is on the list, or it has to be invalid for some other reason, and an attack on the actual basis for the original judgment is not one of those. Having said that, ma'am, what would you like to say about your objections?
I've actually been speaking with a detective, Myron Blackwell, who has been investigating this actual situation, and suggested that I retain an attorney, which is what I'm in the process of doing. Therefore, I can have the actual legal help in regards to that situation and their matter.
So you're requesting an adjournment today?
Yes, if possible, please.
Your Honor, I think that you were spot on with how you started this. This judgment was entered last May. She has 21 days to move to set the judgment aside. She didn't. We've now done, so the time, even if she files that motion, I don't know that it's timely. But certainly what she put in the garnishment, and I believe there's two garnishments, Your Honor. There's a state tax garn and there's a wage garn. The disclosure that we got on the state tax garn is enough to pay off the judgment. So it was going to be my suggestion that we leave the state tax garn in place. The state doesn't release the money till the first week of April. So when we get that, we would pay off the judgment and send her anything back that's left over. But if that stays in place, we would then release the wage garn, because we obviously don't need, we won't need any more money at that point. So that would be my suggestion, to leave the state tax garn in place and release the wage garn. And like I said, if we get money, I think we know that the amount of money we're going to get from the state is $17,1942, and I think once we calculate interest on this whole thing, it's going to be somewhat less than $1,600. So she'll get probably about 120 or so back on her state tax garn, and then we'd release the wage garn.
Your Honor, I actually did receive the form. I didn't receive it until it's dated the 4th of March in regards to the garnishment from the Treasury Department. So I wasn't able to file the motion until I received that documentation, because I was unaware of this process or it being in motion until I received the tax documentation from the Treasury Department. I've recently been involved in another auto accident as well, being the fault of the other vehicle. But so I'm like, mobility wise, I can't drive. So I filed the motion as soon as I was informed and aware that it was in place and in motion.
Right, but I wasn't talking about this being timely. When the judgment was entered in May of 2023, you have 21 days to file a motion to contest that, which is really what you're doing. You're not really contesting the garnishment, you're really contesting the judgment. And that, the time for doing that has long passed.
Your Honor, this is why I was requesting the adjournment. Therefore, I could have a legal attorney who's able to advise me and what I should and should not be doing legally, as far as what should be expected.
Ma'am, I understand what your request is, but the problem is twofold. One, you're talking about the vehicle title was signed over and provided to the plaintiff in agreement that there wouldn't be any further charges or fees.
Yes.
You're talking about you had an agreement with Budget Towing?
Correct.
Yeah.
The exact location of which, from what the detective is still investigating, there's been other cases as well. So, with that being stated, like I said, again, Detective Myron Blackwell. I also spoke with him again today in regards to this matter, and he's still investigating. Which is why I'd like to retain the attorney.
Ma'am, I did hear all of that.
Yeah. Okay.
But may I real quickly, Your Honor?
You may.
But regardless of what she comes up with, the objections to the garnishment would still be invalid. She could at some point file a motion to set aside the judgment, but this motion would still get denied regardless of what an attorney or Myron Blackwell. And by the way, I've talked to my client and they said she never turned over the title. And I talked to the collection agency at the credit bureau, and they said, in fact, she admitted to them not turning over the title. So, but regardless, and I didn't want to bring that up because that's again talking about the underlying judgment, which is a year old. So I would request that everything happen today, that the state tax garn remain in place, the wage garn go away because we don't need the extra money. And if she wants to file the correct motion after talking to the detective and the attorney, she can do that. But this case is going to wind up at the same place whether we adjourn it or not, because this is the wrong motion.
If today I adjourn the motion and give her a chance to talk to an attorney, for instance, and I'm not saying I'm going to do that, doesn't the funds just get held until that next time?
No, I think they get mailed to my client.
They actually, I spoke with the Treasury Department in regards to, and which is why I've had, as long as there is the hearing, they are willing to hold the funds there, which is why I had the documentation facts.
Ma'am, yes. 1 moment, please.
I'm sorry.
Mr. Fantera, my understanding is that they're not going to do anything with this until I make a decision on the motion.
You might be right on that. I don't know. Okay. But again, I just don't think. This motion is going to get denied. I mean, I guess what you could do is adjourn it and give her a chance to file the right motion, but then we're opening up a judgment that's. I'm
not saying I'm going to open it up. I mean, she has to have a valid basis for that. What I want to give her an opportunity is to talk to an attorney. That doesn't mean that her talking to the attorney is going to change anything. It may or may not. But to not give her that opportunity is what I'm having a difficult time with, Mr. Fantera.
Well, except that I can't imagine what the attorney could say. What the attorney could say that would change Your Honor's mind, because everything she says goes to the underlying judgment, does not go to the garnishment. So, I get what you're saying, but I just think we're going to.
The attorney could come in here next week or 2 weeks motion to set it aside, and then I have to decide whether there's a valid basis, and at least she feels heard, whether I rule against her. So, but that way, her issue of feeling as though she has a defense to the underlying matter could be heard, because the way she's putting it doesn't make sense to me.
But the thing that concerns me is, in order to file a motion to set that aside, as we've all learned from the state of New York versus Donald Trump, she would have to post bond in an amount equal to the judgment in order to stay it. Which we've got the bond, it's at the state. We want them to pay it to us. So
I hear your arguments against it. I hear that. All right. I'm gonna give her the 2 weeks. Yeah, I'm gonna give it. How many do we have that day?
in a way, she's hurting herself.
Yes, because the interest is going to continue to accrue on this.
Well, that not only that, but her employer is going to continue to withhold money. I was offering today to release that and send that to the court and send it to her, and she could walk into her employer and they would stop it and give her whatever money they've already withheld. Now what they're going to do, now what's going to happen is both the state and her employer are going to freeze that money. Neither one's going to give it to us, but neither one's going to give it to her.
If I may, Your Honor, I'm currently not working due to my current situation either, which is why this is already hurting me. Due to the auto accident that I've recently had. So I'm currently not working. I'm on leave of absence. And my employer.
All right. So if you had any money coming to you, I don't know if that's true or not, they're going to continue to take that out. Okay. So it looks like we only have 2:30.
We've got 2 at 2, 2 at 2:15, 2 at 2:30 because we just set another one that hasn't gone on yet, and then the criminal matters that we have for in person at 3.
So I'll put another one at 2:30. All right. Mr. Fantera, are you available on April 11th at 2:30? Ma'am, I'm going to be as clear as you can be with you.
Yes, Your Honor.
Thank you. I'm going to give you 2 weeks. And when you come back in 2 weeks, you need to have an attorney. Not adjourning this again. This is the last adjournment. And your attorney needs to have filed anything if they're filing anything by then as well. So you need to get on this right away. Do you understand? Because I'm making a ruling on this. And right now as it stands, would be ruled against.
Can I make one more request?
Yes.
If she does do a motion to set aside, I would request that motion be filed a week ahead of time, because while I didn't respond to this objection because I felt I could do that orally, that I would want to do a reply to. So if you want to go out 3 weeks with the understanding that she has to file something within 2 and get it to me so that I can reply, that'd be or if you want to go out 2 and she has to file something within 1, I just would, if it's going to be a motion to set aside a default or not, I want to be able to reply to that beforehand.
I understand. The problem is that I'm not here in 3 weeks. In 4 weeks, I have already a full docket. So the next time you could come in would be May 2nd. And I don't think that 1 week is going to be enough time to do a set aside. So, and I don't know that she can do it. So,
But I guess the question is that if she does it, I would ask her attorney, because I think you're telling her to have an attorney, to have that attorney call me, email it to me, and I can reply, and I'll reply within 48 hours if I can.
All right.
I mean, if I have to reply orally, I will, but I always think it's better to have
in writing. I understand. So if you're going to have an attorney and they're going to file a motion, that needs to be filed as soon as possible, and your attorney needs to contact Mr. Fantura and let him know that it's being filed so that he can respond or be prepared to respond orally when he gets here in 2 weeks.
Or they
Okay.
can call me and we can maybe resolve this case short of that. You know, I mean, it's always possible to, you know, cut the amount and just cut to the chase. So she's got my phone number. I hope, Miss Carroll, do you have my phone number?
I believe it should be listed on one of these documentations here.
You have the notice to appear?
Yes, I do.
My phone number's on there. So if you get an attorney and he wants to talk, have him call me, please.
Is that the 736?
Yes, ma'am. Your Honor, what time did you say on the